if you could change one law or one real estate policy to improve real estate in India, what would that be?
Abolish RERA.
What are some precautions one must take while acquiring a bank foreclosure auction property?
Parents should not give the property to kid. Never. My take is very simple. If you don't have the wherewithal to look after property, should you be owning it in the first place?
And generally, I don't think even one buyer has got his advocate or lawyer to check the papers in primary.
My only piece of advice is, guys, please go to any decent lawyer and seek his or her advice before signing any document. When you're spending few crores of rupees, why not go to the expert? World Tower 1. Soft commitments for 100 floors building. Little investors had put in money. Simple thing, nobody checked that it was on the flight path. So the top 20 floors didn't get sanctioned. Where would that money go then? You're going to live in the same society for a lifetime. Do you want to make enemies with them on day one, or do you want to live a peaceful life with them?
I'm super excited to be part of this episode of the Real Estate Show with Mayank, because this is the first episode where our guest is actually a senior lawyer. The first time we managed to get a lawyer on this hot seat. His name is Mr. Apurva Agarwal, partner, Universal Legal. He's been doing this for more than 25 years. One-stop shop for all real estate remedies, all your legal remedies. So you know what? I'm not going to talk much. Let's just hear it from him. Hi, sir. Thank you so much for being a part of this and taking out time from your hectic schedule.
Thank you, Mayank, for hosting me. Wonderful to be here.
Looking forward for a enlightening conversation as always. Just a small token of appreciation from our end. Just a couple of sweets.
Thank you.
Your time. This is something I wrote. This is a book that I wrote on real estate. This is for you. I hope you find value in it.
Definitely will.
And this is a part of our green initiative.
Thank you.
Thank you so much again for doing this. Means a lot. You've had 2.5 decades of experience in real estate law and other ancillary issues regarding real estate, right?
Correct.
How did you get into this?
How did I get into being a lawyer?
Yeah, like when did you decide you wanted to become a lawyer?
Okay, let me just go back a few decades. I was completing my 12th in 1993, 1994.
Right.
And I come from a small town, Patna, and from a family of doctors.
Right.
One thing I was sure after seeing my entire family into medical practice, I didn't want to be a doctor. So what was the other option left for me? I didn't come from a family of business, so I could grow that. So I had to choose a service field. Then the other option was a lawyer. So that's what got me thinking. And National Law School had just been set up about a few years back then. So that got me thinking, if an equivalent to IIM is there for law, why not?
That's the best in Bangalore, yeah.
So yeah, amongst the top ranked college today in India at least. So that's got me thinking. I applied there. Thankfully, I was the first few guys to get into National Law School. 7th batch to pass out. And 25 years hence, I'm sitting in front of you, Mayank, talking to you.
Brilliant. Now, can you tell us what's the most common dispute that you have seen in real estate?
Title issue. Vis-a-vis who the owner is and who the buyer is.
And generally, what's the most common type of title issues? Is it more with regards to the succession laws, interfamily?
Okay. See, it's mainly interfamily and succession issues. When the title of property doesn't get transferred legally from the predeceased owner to the next kith and kin, and there are lots of family members involved. People don't realize that they should, through the legal process, get the property transferred to their own names. They don't, for lack of awareness or cost factor or whatever else you can think of. So when they want to come to sell it, then instead of two owners, there may be damn a dozen owners who claiming their rights under that.
Right.
So that's why all the issue arises, and we try to resolve them to the best of our ability. And quite a lot of times we do, but quite a lot of times we have to carry the inherent risk
Right.
along with it. So that's a major defect we find. Another defect what we find is, people get confused between tenancy issues and the license issues
Right.
in terms of ownership and
Right.
transfer, because especially when you're going for redevelopment of
Right.
projects. So that is something which people should understand. Rent does not mean leave license.
Right.
Rent can mean tenancy, leasehold, and leave license. So that's a demarcation where people also have to make for curing the defect or title.
Right. What's the most bizarre case that you fought over the last 25
Most bizarre, I can't comment, but I'll give you a couple of instances where people have gone for redevelopment. In fact, yeah, a couple of days back only, I had a prospective client coming to my office to the society had signed a redevelopment agreement with the builder. Builder had gone bust. Things had not moved well. It's been almost 7 to 8 years. Finally, the new builder took over and handling a position right now.
Right.
So the new builder was asking some documents signed, asked me to verify it. I asked him, before you show me documents, please show me a PAAA agreement. That is a permanent alternate accommodation agreement,
Right.
which a builder signs with each individual buyer,
Right.
with the individual member of the
Existing, yes.
existing members of the society or the tenant. We haven't signed one.
That's incredible.
I'm like, boss, that's your only title document.
My God.
You've given up your flat and you don't have a new title
My
document.
God.
So what do I advise you on what basis? I mean, I was flabbergasted.
Something as fundamental.
Something
as a
as
PAAA.
fundamental as that.
My God.
So, I mean, my only piece of advice is, guys, please go to any decent lawyer and seek his or her advice before signing any document
Right.
or signing off your flat.
Right.
I mean, to give you a classic example, when you guys go and buy vegetables, you guys look at all angles, kacha hai, kachra hai, ye, wo hai, and that's for few hundred rupees. When you're spending few crores of rupees, why not go to the expert?
Absolutely. Which brings me to my next point is we have a division of primary sales as well, right? Where we do a lot of primary transactions with builders. Of course, we're into land aggregation as well, which we are super, because each step is like a landmine there, right?
Correct.
But what I've seen with home buyers, over the last 12 years, we must have sold, close to maybe 800 primary units all across Mumbai, right? And generally, I don't think even one buyer has got his advocate or lawyer to check the papers in primary. Because obviously we work with only branded builders. But even then, even if the builder's branded, till date, no home buyer has ever bothered to involve a lawyer to scrutinize the papers. Of course, that happens in resale and
Right.
land, but why not in under construction? In fact, I personally feel that's more risky. What is your take on that?
See, fundamentally, that I'll tell you why that happens.
Right,
Let me
please.
tell you why it happens, then the risk on it. When I'm buying a primary sale thing, and some people approach me, why would you bet in this? What's your value add? They said, it's a broker बोल दिया ना, and आप तो वैसे भी can't negotiate the agreement out.
Correct.
Then why hire you? I said, boss, you're not hiring a lawyer to negotiate the agreement in a primary sale. That's because that's a standardized agreement under RERA or MOFA, depending on which law you're following. But to tell you what has been complied with and what has not been complied with under the various laws, and to educate you on what you're signing. A builder will give a 50, 60-page agreement, and I can watch for it, man. The 800, 900 people you said, God, not one of them would have read that agreement.
Not
Or
one.
even if one of them would have read it, they would never understood what they've read. So lawyer would explain to him line by line, word by word, what is he signing and what is he getting to, and consequences of default from both the side.
Absolutely. I think that they get intimidated by paperwork.
More than paperwork, they get intimidated by the expense. Why hire a lawyer and pay him an additional amount of money when you're already paying a few crores to buy the house? You're paying a few lakhs to the broker who's found the house. Why pay a
Precaution is better than
lawyer?
cure, right?
No, okay.
Prevention.
Now the second element to that. Again, same question. Ask them why to coming to us. Sir, bank loan ले लेंगे, bank scrutinize करेगा ना paperwork. I said bank will scrutinize it to protect his or her interest,
Interest.
not your interest.
Right.
If a default happens, bank तो हाथ खड़ा कर देगा. You didn't do this, why are you blaming me?
Right.
I have paid you 1 crore, you should pay me back my 1 crore interest.
Absolutely.
So
आपका
you,
मीटर चालू रहेगा.
आपका meter चालू है from the day you take the loan.
Right.
Either from a pre-EMI, EMI, or whatever fanciful jargons the banks will tell you.
Right.
Your meter takes off the moment you take 1 rupee, and it is a multiplier effect.
Right. Is there any way to stop your pre-EMI that you're giving to the bank in case of the
No.
building stuck?
No.
There's no remedy.
No remedy, your money's gone down the drains. So that is the whole reason why we say, please consult a decent lawyer who can advise you on the implications of all the paperwork you've done, why you should do it and why you shouldn't do it,
Right.
and what are the risks you're carrying by signing those documents. So at least you're going with the eyes open, and then you can take a conscious call whether to do it or not to do it.
That makes sense. I mean, it's called like penny wise, pound foolish. Sometimes you
More
wanna
than that.
Yeah, right. You want to save a little fee for
Of-
a lawyer, and then you can get hit.
Correct. Before we get on to this, we are discussing that World Tower 1.
Right.
Soft commitments for 100 floors building, little investors had put in money,
Right.
correct?
Right.
But it was simple thing, nobody checked that it was on the flight path.
Right.
So the top 20 floors didn't get sanctioned.
Right.
Where would that money go then? Another example, Goregaon. Part of the land in Goregaon comes with the forest regime.
Right.
If a lawyer will not check which part of land is in the forest, you can't buy forest land.
Correct.
The builder will not tell you that, the broker will not tell you that, because then present is selling the flats.
Exactly.
That only a lawyer will tell you that.
Because your fees is not success based.
Yeah. We will charge a lump sum fee for advice.
Absolutely. We make, like for us at least, when we are doing land transactions, we don't do anything without
See,
our
Mayank,
lawyers.
yeah, a builder or a person like you whose business is real estate will obviously go to a lawyer.
Yeah, absolutely.
We are talking about people who are buying a real estate for the first time or even for the third time.
Right.
Either first home or second home or office or whatever. How many people will go to a lawyer?
Yeah, I think people must understand that the risks, the stakes are very high, and once they understand that, I mean, I think it should be a must, and
It should be a must, but I
this is
can't
how the
comment.
world, the world works. My next question to you is, as of 2025, like, of course, there's barely any land left in Mumbai and like other urban areas, and the land that's left, there's a lot of litigated land in general. All right, and litigations that have been going on for 20, 30 years. um, to the layman, it feels like those litigations are unsolvable almost, right? What is your take on this subject? Can we amend a certain laws? Is it because of our laws? What comes first, right? The chicken or the egg kind of
No, wait,
question.
wait. I'll correct you there, Mayank. It's not because of our laws. Let me go on record and tell you guys,
Right.
the laws which we have in India across the sector and across the sphere are probably one of the best laws the world has seen.
Okay.
The
Straightforward.
lacuna is people don't want to follow it or execute the key.
Right.
Today, let's hypothetically speaking, if your father dies, leaving behind his immovable property, the flat you are staying in your name, would you go to the court to get the will or the succession certificate done and get the property transferred to your name?
Yes.
90% people don't do it.
Yeah.
Because of the cost factor, that one cost, two lack of awareness. So when they go to sell it off, then process karo, it's a 1 year process, things get lost in the meander. By the time there'll be 10 other deaths happening in the family, lot more,
and it just gets more
murkier
complex,
and
right?
complex. So it's not the law which are at fault. It is the way you execute it, the way you implement it, the way you want to do it.
Right. Do you think inheritance tax will come into India anytime soon?
Okay, mine. just to go back a history a bit, income tax was in existence in India till 1984.
Okay.
It got abolished when Rajiv Gandhi was the prime minister in his first term, and VP Singh was the finance minister.
Right.
I don't know the rationale behind it, but it got abolished at that time. Now, over the last few years, I mean, when the current regime has been in place for the last 10, 12 years now, give it to them, they've been trying to streamline all the tax reforms in the country. They brought in the GST, that doing the trying to simplify the direct
Right.
income tax code, and quite a few things are happening. And they're trying to, generate revenues from people who can afford to pay that. So it's only a question of time. It's a question of when, not if.
Right.
When this tax would be re-implemented and come into force.
So you definitely see that coming in sooner or later.
Sooner or later. We can't put a timeline to it, but yes, it's definitely in the offing.
Right. Now, a lot of like the rich, at least for now, is a lot of families are buying properties in a trust. Right.
Correct.
Is it a legally smarter move to buy a property in a trust? That's my first question. Second is, what are some of the advantages of buying properties in a trust? And my third add-on question to this is the precautions one must take when buying a property through a trust.
Okay. Just to answer,
Yeah.
I'm a firm believer as a lawyer and as an advisor, and I've been advising all my clients to form a family trust.
Right.
And to do all your investment planning and buying of any assets through the trust. Rational being, it's a tool of succession planning. I don't have to go to court if any assets in the trust, because the trustee will tell you who goes where, and it's a living document.
Right.
Number two, it is ring fences your personal assets under one umbrella. Especially for HNI builders, promoters, not in builders, I mean businessmen, business houses,
Right.
who are giving personal loan, who are giving, sorry, not personal, taking loans and giving personal guarantees.
Right.
If anything goes wrong, then your personal assets can be attached.
Right.
If it's a name of trust, it cannot be attached. So that's a succession planning. Number two is your
The advantages of
your insolvency thing. Number three, right now we're just discussing inheritance tax.
Right.
If inheritance tax comes in and is then US and
Right.
some other places, so if they inherit any property from you, since that country, they pay about 30 to 40% inheritance tax. Now, if you have this in the name of trust, you're not inheriting that property. The property remains with the trust. So technically, then you don't pay inheritance tax.
You evade inheritance tax
You
as well.
don't evade inheritance tax.
You
You
never
avoid
it. You were never
There's a
wanting to. You were never selected to pay.
You're
it in the
not
first
liable
place.
to pay it.
Got it.
There's a difference between evasion
Yes,
and
absolutely.
avoidance.
Absolutely.
Evasion is a crime, avoidance is not.
Absolutely. Absolutely. See,
Okay.
that's a difference between a lawyer and a layman.
Right. So we firmly believe that a trust as a structure for any business house, any builder, any person who is into business or running a portfolio or anything, is the key to move ahead.
Right. And what precautions one must take while setting up this family trust?
See, your trustee should be absolutely clear how the money has to be invested, and how and to whom it should go, and at what ratio, what proportion. That has to be clarity of thought, because that becomes your family constitution.
Right.
Number two is to identify the correct trustee to manage your trusts. And let me put it on record, there are lots of banks and financial institutions who offer that kind of services. I won't name them because it's not appropriate for me to name, but there are lots of banks and financial institutions who offer that services at a reasonable fee.
Right.
So approaching them would be the best bet to act as a trustee.
If you could change one law or one real estate policy to improve real estate in India, what would that be?
Abolish RERA.
Which brings me to my next question, which I only got the answer to. Is RERA toothless?
RERA, I mean, intention was good. I don't doubt the intention, but the way it's been implemented or drafted, it's leaving a lot of home buyers with no escape or no tooth to fight the builders.
Builders aren't scared of RERA.
Whether they're scared or not scared, that's a different question. We can't answer that question. I still believe MOFAs, which is the Maharashtra Ownership
Hmm.
Flat Act, is a more effective tool for a home buyer than a RERA is. So today, I'll give you some examples. Today, if a project is registered under RERA, gets deregistered for any reason whatsoever,
Right.
for whosever fault, I'm not going to say builder's fault, my fault, the home buyer or the flat buyer, whatever, doesn't have a recourse under RERA
Right.
then where does he go? You're still going back to move find other cause of action, then why have RERA? Number two, that certain exceptions to RERA. Like if I'm selling only after the OC has been received, then RERA is not applicable to you.
Right.
If,
Exceptions with the
if
500
that
square meter.
500 square meters, less than 8 flats, then
Right.
RERA is not applicable to you.
Right.
If you have to have so many exceptions, then why have a law?
Right.
That's why I prefer MOFA because it's applicable throughout.
Also, is the criminal angle, the lack of that, an issue?
Point well pointed out, Mayank. MOFA provides for criminal action against builders in case they default in certain provisions of MOFA, including not resting agreement and handling possession or delayed construction
Right.
and defective construction under
Right.
Section 4 MOFA.
Right.
RERA does not provide for any criminality. So today, for me, if I'm acting for a home buyer, I would rather prefer going under MOFA than under RERA.
Right. Now, what happens after a RERA judgment? Just hypothetically, say a builder doesn't comply with a judgment of the appellate tribunal. What recourse does a home buyer have?
Home buyer can approach the High Court as an appeal. That will take a few years. Again,
Then I have.
so that's what I'm saying. Why have a body which is toothless and doesn't have the right, cannot enforce its own decisions?
And between consumer court and RERA, what should a home buyer choose?
I will go to consumer court.
Consumer court. And now, in case many times we've seen where the builder has filed for bankruptcy, he can't complete the project because of bankruptcy. Has NCLT been effective?
See, from a home buyer's perspective, NCLT is a good tool, provided there's a big caveat in this. All the home buyers, or at least a majority of them, come under one roof and fight as a group. If there are 20 buyers and each one go individually, it becomes a non-effective tool.
And which is the real challenge, right? I mean, gathering everyone.
Which is a challenge. One, all 20 of them don't know each other.
Correct.
Because the builder will never introduce any
Absolutely.
prospective buyers to anybody. So you don't know anybody. So how are you going to collect that information by it out? Correct?
Absolutely.
That's one challenge. Two, even if you're able to trace so many of them, trying to align everybody's interest under one roof is always a challenge.
Right.
So these are two things which we.
Yeah, it's a real practical challenge.
It is a practical issue.
Now, do you think the force majeure clause is being misused in RERA?
What force majeure clause?
Like to get extensions. Anyways, you don't even find RERA. You find RERA completely toothless, so it doesn't matter.
That's what force majeure clause are you talking about?
Correct. Getting extensions because of pandemic, because of act of
Wait.
God.
1 year automatic extension you get anyway.
Right.
How difficult is it to get another extension?
Actually, when you don't have faith in the entire body, then what good is
It's not a question
an
of
extension?
faith. I mean, today, the ways and means of handling everything.
My next question to you is, I read a judgment where the appellate tribunal said there was an existing tenant who's, of course, and it's a double whammy for existing tenants when you do redevelopment, because A, they've broken your house, right? You
Correct.
had a house which they broke.
Correct.
And of course, construction didn't happen and it's been delayed. He had approached RERA, and
A tenant cannot approach a RERA.
so that's my question. The judgment was that he's not considered as an allottee.
He's not.
He's not. All right. So what are his remedies?
He has to go under the Consumer Protection Act and contractual dispute. If he's executes the PAAA agreement, which has
which wasn't
done in quite a lot of
ridiculous.
matters, which I just put.
Ridiculous.
So that's a contract default by the builder. Approach the relevant court for enforcing rights.
Right. Now, redevelopment in general is becoming extremely popular in Mumbai. What precautions should existing tenants take? That's number one from a legal standpoint. And generally, what demands should tenants have from the developer?
See, I'm not going to talk about the commercial aspect
Commercial, yeah,
because
fair.
that's, I mean, even though we know it, that's not my
But I
expertise.
still want to hear it from your angle. Like, how would you structure, say, a redevelopment happening in your society?
See, if a redevelopment is happening and I'm on board as the legal advisor, one, we need to have a strongly worded redevelopment agreement which the society does with the builder, which will have the default clause, a step-in clause. What I mean by step-in clause is, in case the builder defaults in complying with the terms and conditions of the agreement, the development agreement, the society will step in and complete the construction on its own and appoint another builder. That's a step-in clause. Number two, ensure a bank guarantee or a financial instrument which is encashable within 30 days from a builder to the society.
Right.
So normally in all the redevelopments which I'm acting for society, I ensure that the builder gives a bank guarantee to the extent I would need to complete the construction of that building.
Right.
How the builder arranges is not my perspective.
I feel like existing home buyers are just worried about how much area will they get additional.
Okay, now that's a point which I would like to address. When you're negotiating with the builder, I'm not saying don't ask for bigger area, but that should not be the sole criteria for you to appoint a builder.
Correct.
I would rather go to a builder who commits to less but has the ability to complete the project on time, rather than go to a builder who will commit to 5x but doesn't have the ability to complete or
What good
get the
is- yeah,
permission in time.
yeah, absolutely.
So then you're living a dream,
Right. Mr. Apurva, how legally binding are builder allotment letters?
RERA recognizes them. Enforceability is always a challenge. Okay. So I wouldn't want to have an allotment letter at my thing and try to defend that because it's a very gray area. I would, if you're buying a flat, pay 10%, under RERA, pay 10% or more, the builder is obligated to get the agreement registered.
Right.
And that can only happen after the IOD and CC is received.
Right.
Because that's when all the plans come. I always tell whichever home buyer comes to me, pay the 10% at time of IOD CC and get your agreement registered. And or better still, I'm a big fan, if you're buying a home to stay, which is your so-called first home, your dream home, don't ever buy an under construction building. Pay that 5% premium more, buy a ready building, probably brand new if you want to, which has OC, pay that 10%. एक हाथ से चाबी लो, एक हाथ से पैसा दो.
Absolutely.
That is my fundamental advice I've been giving to all my clients, whether secondary sale, primary sale, whatever sale you call it. First home, I always say, just to secure yourself. And somebody wants to understand the math is very simple. No builder will give you a under construction property in less than 3 years.
Right.
Even if it's the smallest building. You are staying in another flat and paying rent for 3 years. You are paying the builder construction like payment over 3 years till you get possession. So you're getting double whammy anyway.
Right.
Might as well pay that 10% upfront and get the flat and don't pay rent any longer.
Absolutely.
And convert that rent into an EMI.
Right.
As a loan.
And your guaranteed possession because it's ready.
Because you're already you're in it, staying in it.
Absolutely. Now, just wanted to, your viewpoints on this. This is not a legal question, but like, say in bigger projects where there are multiple phases and buildings, as a home buyer will pay the entire 100% amount gradually over a period of time, and on his final payment, he'll get the possession of the apartment. But we've often seen in bigger projects, the amenities are not ready. Now, the home buyer bought into the project. He's bought into the apartment, yes, but also at a macro level into the project. The amenities are not ready. but he has paid 100% of the funds.
Okay.
How fair is that?
Okay. Again, the two sides of the coin.
Right.
If the builder completes the amenities on day one, before completing the entire project, who is going to maintain that amenity? The cost of maintaining the amenity will still be 100, whether utilized by 5 people or by 100 people.
Absolutely.
So will that 5 people undertake to pay 100 rupees?
Absolutely. It'll be way more for them, in fact, because there's only one building has.
Correct?
Right.
So that's one aspect we need to look at. So the builder will say, if I hand it to right now, are you willing to pay the entire maintenance bill for the amenity? Most probably the answer will be no.
Absolutely no. Yeah.
So that's why the builder tends to complete it simultaneously, because also his other towers, that money is also going to be used to pay to construct the amenities, right? Not only one tower. But in all fairness, if I paid 100%, I should be able to access amenities. So it's a two-side coin. There's no clear-cut answer to it. But we have to understand each other's perspective.
Right.
Then you might as well buy in a tower which is coming up closer to the time when the amenities are being completed.
Or when, say, in a smaller project where both the towers will get ready at the same time. Right. Interesting point, actually, because the maintenance is, very
That's the
interesting
key.
point. Now, what is the worst trap, or some of the precautions a landowner must take while getting into a joint development agreement with a developer?
Okay. Now, it all depends on when you want the compensation, how much compensation you want. We've seen cases, I won't name the brands,
Right.
where one of my clients had entered into probably the top 5 branded builder GVA for a 10-acre land parcel in eastern suburb of Bombay. Time commitment was between 3 to 5 years. Project will be completed. You get your profit share was agreed at a certain ratio, and we'll walk out. Project got delayed by another 3 years. Compensation wasn't as much as the landowner perceived it to be. Still regrets that decision.
Right.
So when you have to sell another plot of land or get it again sold amongst the top 6, top 7 to another company, not the same company, but then he went for conveyance of the property.
Right.
कि आप लैंड ले लो मुझे पैसा दे दो. I'm not going to go to JDA.
Mhm.
Okay. Rational, once bitten, twice shy.
Right.
Now the thing is, we must understand how big the brand is. It is still run by human beings. And the same engineers and same architects. They're no different. The bigger brand will show quality over quantity and stuff like that, yes.
Right.
But my take is very simple. Why not take the money up front and let the builder do what he or she wants to do?
A lot of times, builders push the landlord that we don't have money, we want to be asset light, we don't have money to block in the land.
That again, I would say is a misnomer. Any builder would want to spend less or block his capital to do any project. Even you, even I would
Right.
want to do that. If somebody likes my piece of land and wants to do a project, that's just coming to talk to me. He won't be wasting his time otherwise.
So you have to stick to your guns and say that, listen, just take the conveyance and give me the money.
Take the conveyance. Why wait for something? What will happen 5 years, 7 years down the line? I'm a
Too
firm.
many variables can go wrong.
Too many things can go wrong. COVID can happen. November attacks can happen. Terrorist attacks can happen. 26 July can happen.
My God.
All this happened in our lifetime. I'm not talking
Absolutely.
something
Yeah.
which has not happened in my lifetime or your lifetime, man.
It's all
COVID
happened.
things were shut down for 2.5 years. 26/11
Absolutely.
happened in our lifetime. 26 July happened in our lifetime.
Yes.
I'm talking about 3 major incidents, force major crime which happened in your lifetime. It's not hearsay.
Factually.
Correct?
Absolutely. A lot can go wrong, and nobody can predict the future.
If I could, I would be God today.
I would definitely come to you more often. Now, what is your take on a more serious approach? Developers, it's become a fashion now. Building is ready. The OC is not come, right? But they give the so-called fit-out possession to home buyers to do the interiors. What is your take on that? Should homeowners pay the entire 100% of the amount and take that so-called fit-out possession without the OC.
Take the property for fit out, yes. Take possession, no.
So they've clubbed it too, right?
Huh.
A lot of they call it as
So
fit-out possession. Yeah.
I would say I'm taking it for fit outs. I'm not taking legal possession of the property.
Got it. Got it. So you want to have that clear demarcation between the two.
Correct.
Absolutely.
Because legally speaking, the builder cannot give me possession till the OC is not received. Otherwise, it's in breach of the RERA and MOFA and the various other real estate laws which I'm not getting into.
Now, a lot of residential buildings in Mumbai are built on leasehold lands, right?
Correct.
From, say 30 years to 99 years. Now, what is the risk of living in an apartment that in a building that is built on a leasehold land? What are the risks? And what happens once the lease gets over?
Okay, let me give you an example of this. Slightly different context, but it will explain this context. In Delhi, we have got a Taj Mahal hotel, prime location.
Right.
The lease, it was a Delhi Municipal Corporation lease
Right.
to the hotel. It expired a few years back, and the DMC wasn't renewing the lease.
Right.
They said we'll auction it off. Whoever bids for it gets it. Now the entire Taj group went for a sales because they had built the entire. That was the iconic hotel.
Right.
They went to court, they explained to DMC, and somehow managed to put it through and got it reallotted to them. So that is a risk which you're carrying. You're not sure whether the leasehold will be renewed or not be renewed, and if renewed, at what terms and conditions.
At what terms and conditions?
Taj can afford to pay that, you can't. So that's the inherent risk you're carrying, one. Number two, whenever a flat owner wants to sell his or her flat to a second person, which he would or she would at some point of time, then I have to go back to the lessor to get the NOC. To get the NOC would mean a transfer fee, which is a percentage or whatever it is,
Right.
or a fixed fee. I'm not too sure. Every lessor has a different combination, permutation. Like in South Bombay, the collector's land.
Right.
We have the Bombay Port Trust in most of the areas.
Right.
And then we got the Sidco leasehold land, we got the MIDC industrial land.
Right.
So in fact, 60 to 70% of land in Bombay is a leasehold land.
Right.
So that's an inherent risk of kind transfer fees plus renewal terms and conditions. So when people ask me, I said, are you staying on rent or are you staying on ownership? Get that demarcation clear. Or look at it कि मैं lifetime हो जाए, मेरे बच्चे को क्या होगा, I'm not bothered. That's the second way of looking at it.
So you would always recommend?
I would always
freehold.
recommend a freehold land and a freehold flat. In fact, currently while we speak, we are again in midst of doing a transaction where we are converting a tenancy building into ownership building. About 80 members, and in fact, they're paying a certain amount above the rental, and I won't, some 100 times more than that, and
Right.
getting. Even the government has that scheme.
Right.
If you pay a certain amount above the rental, which is a multiplier effect, we can convert a leasehold land into a freehold land. So we've been trying to tell the societies do that.
Right.
But the problem with the society is, I wouldn't say most, I would say all of them, ability to pay that kind of money and willingness to pay that money. I may be able to pay that money, but am I willing to pay that money?
Right.
To convert the leasehold, the Indian psyche, wrongly or rightly, I'm not going to debate on that. काम चल रहा है ना तब क्यों खर्चा करो? You're not losing out on the larger picture कि property मेरी होगी ये. I don't have to go to a third party to get approvals.
What is your take on builders charging transfer fees even after 100% payment has been received by them and the conveyance has been done?
The builder will charge till the society is not formed. Number one. Transfer fee is provided as per the model bylaws and capped at 25,000 rupees per flat per transfer. So anything above that is technically illegal, even for the society.
Yes.
Legally speaking, the builder has no right to transfer any transfer fees because he's not supposed to be managing the building or the society at all. That is supposed to be done by the society, and he's supposed to make the society within a certain timeline of 10 or 20% of the flats being sold,
Right.
which they don't do because they
Which
want
they-
to have control till the very end.
Right.
So that is technically illegal. And even if we charging, cannot charge more than 25K
Right.
per transfer. But the ways and means where people charge premium, this, that, and
Donation or something like
charge.
that.
And that I would say not only builders, that's across with most societies also.
And it's very rampant, in fact. Like societies, even like 25,000, it's much more than that. And they obviously they have their own ways to.
It's normally a percentage,
Right.
which can vary from 0.5% to a couple of percentage points down the line.
Right.
But technically, it's illegal. Now, why? Then your question should be, why do people pay it? Why not
Yeah.
go to corporate court and find a solution? The answer to that is you're going to live in the same society for a lifetime. Do you want to make enemies with them on day one, or do you want to live a peaceful life with them?
Absolutely.
If you answer that question, it will solve it. You'll get your answer why people are paying or not paying.
Also, a lot of societies are discriminating basis a person's, religion, right? In fact, not in societies, including builders, right? Can societies and developers not sell you an apartment because you're from a certain religion? Of course, we know it's unconstitutional, but it's happening out there. Now, what legal remedies does a person have in such a case?
I have a different take on this.
Right.
A builder is not a state, it's not a government entity.
Right.
So I have a choice to sell my apartment to who I want to sell it to. Today, can I come and tell you, please sell the flat to me, don't sell it to XYZ? No, I don't have that right to tell you, you as a builder.
Right.
Can I force you to sell it to somebody or not to sell it to somebody? Today, why this so-called discrimination, positive or negative? Positive discrimination, I will only sell it to one kind of person. Negative is I will not sell it to this kind of person. Correct? It happens both ways.
Both ways.
Why people positive discriminate? Because they can command a premium. Let me forget religion.
Right.
Let me go to another extent on dietary preferences. Only vegetarians allowed in this building. If I can afford it and I'm a vegetarian, I'd rather stay in that building than any other building. Or in some buildings, I will see a Jain mandir being made. Correct? Jains love that.
Best amenity, in fact.
Best amenity. They don't want anything else. Jain
No pool, just give me a, yeah, absolutely.
Okay. So all the Jains will pay a premium to stay in that building.
Absolutely. We've seen in belts in Lalbagh, Parel, Baikla. It's the
Correct.
number one thing they want.
In where I sit in the building next to my building, there's a prayer hall for the Muslims.
Right.
So again, that building, it's a Cosmo building, but predominantly has that one kind of.
Right.
So if you give certain kind of amenity, then obviously certain kind of class of people will predominantly go and stay there. So that's what you call positive discrimination.
Positive discrimination.
I mean, if you ask me whether I should be doing it, answer is no. But as a builder, and he or she has every right, according to me, to sell or create amenity as per his or choice. Whether people accept it or not is their choice. So that's my take on it.
Right. Now, overarchingly, right, what are some of the common mistakes that you have seen home buyers make while buying their homes?
Okay. Number one, choose between budget and location. Don't confuse the two. Suppose my entire ecosystem is built around Bandra.
Right.
I cannot shift Bandra for whatever reason.
Right.
Then don't have a budget in mind. Or if I have a budget in mind, don't go beyond that budget because then it's going to
Right. Breach it.
breach everything. Number one is that. Number two, be clear as to what you want in the flat. For example, when I was buying my flat, where I'm currently staying, I was very clear I don't want any amenities in the flat. And in the building, sorry, not in the flat.
Right.
I didn't want to go to a place which has a swimming pool or a clubhouse or. I mean, my logic is very simple and I may be wrong in that. I'm not saying my perspective is right. was how many times a week or day am I actually going to go and jump into the swimming pool?
Right.
And number two, will the society be able to manage that and maintain it after the builder steps out? There are quite a few times when I've seen swimming pools being closed down because the society is not able to manage it for lack of time because everybody's doing it as an only job.
Yeah.
Nobody's paid to do it.
Right.
So I will devote time to society only if I have time to devote to society,
Right.
not as a first priority. And my third logic was that I'd rather take a membership club, which is professionally run, and enjoy the facilities there as and when I need to.
Right.
So be clear on what kind of amenities you want, be clear on your budget, and be clear on the location. Number four, do not rely on the experts in the area and take an informed decision. When I'm saying experts, rely on your real estate consultant broker to find your right budget for your right location. Rely on a lawyer to check the papers properly before you buy the property,
Right.
whether it's primary sale or secondary sale. Rely on your bank loan guy to tell you how much loan you're going to get. So your budget will depend on that. Budget 20% extra on your budget to spend on a flat. Suppose you have budget of 1 crore. Don't forget 6% is going on stamp duty and registration. That's an
Make
adder.
sure you add that as
Add
well.
that. You're not going to stay in a raw flat.
Right.
Even if it's a furnished flat, you want to redo the furnishing, you're like,
Make sure you know what the unforeseen charges
Charges
are.
are. which people don't. 1 crore का budget है, suddenly stamp duty नहीं गिना, furnishing नहीं गिना, ये नहीं गिना, things go out of budget. So keep these factors in mind before you buy anything.
What is your take on bank foreclosure properties? Obviously, they do come at a discount. What are some precautions one must take while acquiring a bank foreclosure auction property? That's one. Two, can the existing previous owner reclaim such properties?
Okay, answer second part first.
Right.
Previous owner cannot reclaim those properties.
Right.
That's very clear. Bank foreclosure property, I would first need to, basic thing I should know is what are the liabilities on the flat. Liabilities on the flat would include the bank loan repayment, which I need to repay the bank.
Right.
That will be a fixed amount. Society dues, if any, for the maintenance charges.
Right.
Property tax dues, if any, correct? Electricity bills, if they are undue, are not paid up to date.
Right.
Any other statute dues which may have been there, like the collector charges in case of BPT land or anything,
Right.
which have not been paid for the previous time. And if any of the documents previously have been registered or not registered. I need to check all these liabilities before I decide whether I should buy it or not buy it.
Right.
Because suppose if the market value is 100 and you're thinking you're getting a deal at 60 because the bank only has 60, if you add up these liabilities, it comes to 110, it's a no-brainer.
Right.
Then why would I buy it?
Wow. Then it's not a discount anymore. I'll just
Yeah.
buy a clean.
Then I might as well buy a clean property.
Right.
So I'm not saying all the time, quite a lot of times people just go in the bank से मिल रहा है सस्ते में मिल रहा है खरीद लो.
But the hidden charges are
Charges
so much
people
in
realize
quantity.
later
Right.
because the banks will not tell you all the charges.
Right.
They don't have the capability to tell you all the charges.
Right.
उनको तो अपने लोन से मतलब है आपके जो 100 मुझे 100 मिल गया ना बस सोसाइटी का क्या है टैक्स लाइन भी क्या है आई डोंट नो सो प्लीज फाइंड आउट ऑल दैट बिफोर यू डिसाइड टू बाय अ बैंक फोरक्लोजर प्रॉपर्टी
Is conducting a SOCI search report important, and how many clients of yours have approached you specifically that we want to know whether there's any encumbrance on the property? Can you please conduct a SOCI search report in specific?
See, all the it's not how many clients will not come and tell me conduct a search.
Right.
It's the other
It's
way.
the other way around.
If the clients
not
come to
aware.
me to buy a property, we advise them the kind of searches we've done and the legal process around that.
Right.
So we'll tell them, incumbent certificate search, title search, newspaper ads, check where the original papers are.
Right.
Okay, just on the record, I'd like to say why we give a public notice. There has to be some rationale, right?
Right.
Remember, banks, when they give a loan, they're not compulsory required to register those mortgage deeds
Right.
under the Transfer Property Act.
Right.
So even if I do a search and the property is mortgaged to bank,
It's
it
not
will
gonna
not
show
show up. The rationale giving a public notice is that
To invite objections.
change, and the banks will read those notices and object to it.
Right.
So this entire process which we carry out
To capture the registered market and the
unregistered market,
yeah.
and also at times we do a background check on the sellers,
Right.
on a person.
Right. So do you also recommend a litigation search on the person?
There's
as
a
well?
litigation search on the property and the person.
Right.
Title search, if it's a seller's the company, to ROC search
Right.
on the company, because then the mortgage will be registered on the ROC website.
Right.
So there are quite a few things we do. So therefore, when people say bank kar lega when I'm taking loan, why did I have a lawyer? Because we do the extra searches to double verify what a bank would not be able to do.
Now, when you're conducting a search report for the title, right? Generally, we've seen people go back 30 years, right?
Right.
What is 30 years enough according to you?
Okay.
Historically, what
wait,
was your
the
take?
rationale of going back 30 years, because in India, no mortgage deed is beyond 20 years.
Right.
So we add 10 years back to go back at 30 years to see anything in existence.
Right.
If we find something amiss in this 30 years, then we go back another 30 years
Right.
to double verify anything. Because we are mindful that we have to also look at the cost which are charged to the client.
Right.
We will go that extra mile if we find lots of defects in the title.
Right.
But in case there are no major defects, we are happy with the 30 search because mortgages don't last for more than 20 years.
Okay.
So 20 plus 10, 30.
Okay. So you got that buffer, and 30 could be okay. My next question to you is: does probate always mean a will is genuine, and how easy is it to challenge a probate in India?
Okay, wait. What does a probate mean? It's a process, if it goes unchallenged, it takes about 6 months to a year in the courts in Bombay.
Right.
It means the court has verified the will to be genuine, original, and proper in all aspects.
Right.
And the process is carried out thoroughly. In sense, notices go to all the legal heirs, public notices are given, affidavits are given. It's an entire process. It's not
Right.
कि भाई आज आप उठे कल आपको
ले लेगा.
ले लेगा. So if the probate has been granted, there's no reason why it couldn't be challenged unless it's proven to court that the people who went to obtain the probate had done a criminal fraud by obtaining false signatures,
Forgery. Okay.
forgery of signatures.
So it's not that easy to challenge.
Right. And that can be done only on limitation period of 7 years.
Okay. There's a 7 years
Right.
to that. Right. Some precautions while buying ancestral land from the seller.
See, first, as I said, suppose the land was originally owned by a person 60 years behind.
Right.
I would then go back 60, 70 years
Right.
to trace the history, not 30 years.
Right.
I would try to trace the family history of that person. I mean, whether I should say it on public or not, was he married only once or multiple times?
Right.
How many kids?
No, we've come across that all the time.
Yeah,
Like,
I mean,
very-
practically, legally, it happens.
yeah.
Okay.
Yeah.
How many wives, how many kids from each wife?
Right.
Where are those kids? Has they relinquished the rights, not relinquished the rights? All that we try to double check. And then try to come out and say whose signatures we need and whose we can avoid.
Oh, whose we can avoid as well.
Right.
All right. And generally, whose can you avoid? Like what
It's
degree of it's
Case
there's
to
no-
case.
there's case to case.
I'm
There's
not
no
going to
blanket.
give you an open blanket
Correct.
statement to that, but it's on a case to case basis. We've had cases when even a person who had a 3% right, we made him sign a document.
Right.
Okay, pay him 3% of concession and get him off.
Right.
The challenge when a person, because the person who's got the smallest payout has the maximum ego.
And the
Because he's
maximum
got-
negotiation, this thing.
Because he's got nothing to lose
yeah.
and everything to gain.
You can spoil the entire deal just because you have
Right.
a share. So, absolutely. Now, parents often, because out of affection and love, gift properties to their kids.
Parents should not give their property to kid.
Period.
Never. Period.
Period. So every parent watching this, please take note.
Despite
coming
whatever
from a
age, despite love and affection, they'll take good care of me. Till you have the money, your kids will take good care of you after bullshit. sorry to use that word,
And that's totally
nobody's
fine.
going to take care of you.
So, they do it by a registered gift deed, and then, of course, after 10 years, we've had cases where children can kick the parents out of the house.
They do?
They do. So, is there a certain clause that one can put in a gift
Okay.
deed to?
Wait.
Yeah.
Okay, I'll just explain
Yeah,
what these are. The two types of gift deeds.
Right.
One is what we call an absolute gift deed, which you just spoke about, all my rights transfers.
Right.
The second gift deed, which we advise parents if they insist कि मुझे करना ही है, and part of the section plan, what we call a conditional gift deed. We are gifting you the property today, but you don't have a right to sell the property. I have a lifelong interest to live in the property, and you have got no right to mortgage the property. So it protects the parents to that extent till lifelong.
So that is, if someone were to do it, then you would recommend
A
this.
conditional gift. Suppose they still go and do an absolute gift against sane advice. There are provisions under the CRPC, the old CRPC. I haven't read the new criminal code.
Right.
And there's a act called the Maintenance of Senior Citizens Act.
Right.
Where if the senior citizen or parents are being harassed by the children and they have gifted the properties to the children, they can approach the court to cancel the gift deed. Irrespective of that, if you can show that undue influence or coercion has been done, coercion means force, and
Right.
undue influence, no, people just show their love, ultra love and affection, get them to transfer property.
Right.
We can go to court and get the gift deed cancelled.
Right.
But that's a process.
That's a process. So it's better not to even.
Fundamentally, as I keep saying, and I mean lots of senior citizen parents, especially when their flats are going for redevelopment.
Right.
जैसे मैं बच्चे लोग को गिफ्ट करता हूँ, अब उन्हीं के पास जाएगा. I vehemently stop them. कि जब तक आपके पास पैसा है, वो लोग आपको पूछेंगे नहीं तो कोई नहीं पूछने वाला.
Correct.
Okay, and आप अभी दो या 10 साल के बाद दो, what difference does it make?
Now, how would you explain the concept of adverse possession to a layman in the simplest of terms so our viewers can understand?
Okay, very simply put, if I own a property, somebody else is illegally possessing it for 14 years or more, and I don't do anything to evict that person, that person can claim adverse possession. Illegally. What I mean, you don't have an agreement in place, or like a rental agreement or tenancy agreement or leave license, then that's illegal. If I have an agreement in place, then nothing wrong with it.
Right.
If there's no written agreement duly registered, and I'm illegally occupying the property for 14 years plus, without the owner taking any legal action to evict me,
Right.
I can claim adverse possession
Right.
and complete ownership of that property.
What is your take on this rule? Do you think it should be abolished, or are you in support of this rule?
Nobody's asked me that question before. Okay, very candidly speaking, I think slightly differently. My take is very simple. If you don't have the wherewithal to look after property, should you be owning it in the first place? And 14, 15 years is a long time. We're not talking about 1 or 2 years.
Right.
But that does not mean what the other person is doing is right or wrong. Legally speaking, this rule should not be there in the first place, because it's my hard-earned money or my family's hard-earned money which is going down the drain.
Right.
I may or may not realize it because of lack of paperwork, documentation. Sometimes, this one generation by two generation, people bought properties without informing their children,
Right.
or they just passed away without doing anything.
Right.
So that knowledge may not be there.
And what do you have to prove this in court to get the actual?
Yeah.
And how can I prove it in court that I have
Adverse possession.
Yeah.
Your electricity bills will be in your name.
Right.
From whatever, your ration card will be in your name for showing that address.
Right.
Your passport will show that address.
Right.
So
This
lots
is of the person who's occupied.
Right.
Okay.
Right.
All right.
If you're the owner and want to evict that person, the ownership property papers will be in your name. That is something which he cannot have.
Right.
So then you have to show that, or it will be in your ancestor's name.
Right.
Then you have to trace the history, show it belongs to my dad, granddad, now
Right.
it belongs to me, rectify it and get things moving.
And you are in support of abolishing like this
Yes.
law, right? Now, fundamentally, fundamentally, can you tell us the differences between a lease agreement and a leave-in license? And it's often said that a leave-in license is safer and favors landlords more.
Okay,
Is that
let me
true?
just go back a few
Right.
lines. When you travel outside your hometown, where do you normally stay?
In a hotel.
You get a room key, you stay in the hotel room, correct?
Yeah.
What rights do you have in that hotel room?
Just to occupy that for say 2 3 days.
Right to occupy. Can the hotel owner enter the room and take away possessions? Yes or no?
Can the
The
person living,
hotel owner,
hmm,
enter your room and take away possession?
legally, I don't know, but I don't think
No.
that I'll
Uh,
get irritated. I'll be pissed. No,
no,
for this 2
no,
days.
he can't.
Right.
What is that right you have then? That's a license. Right to occupy. That is the same concept which is extended to a leave-in license agreement. It's an easementary right
Right.
under the Indian Easement Act. Okay, so it's a personal right. Right to occupy without any other right for a fixed term for a, on the for the of the property.
Right. And how is that different
Okay.
from the lease agreement?
Lease. So in a right to occupy, you don't get possession of the property. Right to occupy, as you rightly
I
said.
understand. That's a license.
Okay, the hotel owner can enter your room at any point of time. So if you see, the master key is always with the management.
Ah.
The housekeeping happens behind your back. Cleaning activities happens behind your back. This doesn't happen in front of you, right?
But
Same
that's a
thing.
license.
Yeah. Same thing extended to the leaving license of property. The agreement will always say we hand you a duplicate set of keys to you for to occupy the property.
Right.
We never say possession. And the licensor has the right to inspect the premises by giving you 24-hour notice. So you don't get legal right at all. In a lease, you get possession of the property. So you cannot evict the person. And in case you die, it will go to your next of kin
Right.
for that period of time. Suppose you sign a lease for 10 years, suppose you die 3 years down, for remaining 7 years, your next of kin can enjoy the property. In a leave license, the next of kin cannot enjoy the property.
Right.
So these are two basic fundamental differences between a lease and leave license.
Very well summarized. Love the example of the hotel actually. That really broke it down because you get just like how you get the set of keys for a hotel, you get a set of duplicate
The
keys
case for the
for a
leave.
leave-in license. And
So you
even in a
cannot
leave-in
change the
license,
lock in a leave license property. You can change the lock in lease property.
right? Can't change the law because of that, right? No ownership rights. I have a habit of writing down, interesting points that I've come across. So in a leave-in license agreement, the landlord can just show up to your door anytime without giving you advance notice.
Legally, yes. Sub-
Legally, yes.
Subject to what the agreement says.
Maybe on humanitarian grounds, on social grounds, they won't
So,
do it, but
yeah,
legally they can just show up.
yeah. So we actually, when we are drafting the leave license agreement, we provide for that. That will give us some time notice to the licensee
Right,
before showing up. I mean,
right,
it's not good, not that licensee will be at the home 24/7 or office
right,
24/7. So
right,
gives him some provision, give him some time like to show up.
right.
So we normally
So
say
can I
24 to
say
40
that
hours.
the person in the leave-in license is the occupier?
Yeah,
Is that the right word to
he's the
use?
occupier.
Right.
So therefore, in any of the leave license agreement, a properly drafted one, I'm not talking about
Properly drafted one.
the
You
word
choose.
possession will never be found.
Right.
You'll always use the word occupier or occupation of the property.
And in lease, you'll use the word tenant or
Lessee.
lessee,
And
lesser.
lessee and possession.
Right. And what would a term like tenant be? Because it's seemingly like a very broad term nowadays.
See, okay, a tenant has a better right than a lessee and it's for a longer period of time. These are, the old Pagri system and
Those tenants, right?
1985 before.
Right.
So those are tenants.
Right. Because, colloquially speaking, we always say, oh, there's a tenant in that apartment 601, there's a tenant. But
So those are actually licensees.
there's a licensees.
Not a tenant. So in tenancy, what used to happen still, tenancy and Pagri are more or less the same thing.
Right.
Okay. Where you pay a high deposit and very low rental.
80 rupees, 100, 500 rupees. In the long run, I mean, the buildings they can't get
That's why the
maintained.
buildings are
Yeah,
depleted.
Yeah.
Because you can't even afford to pay the property tax of that building.
Right, absolutely. I mean, now I think with all these redevelopments, with 33.7 coming in, hopefully we'll see Bombay change.
Hopefully.
Hopefully. I had a great time with you, and thank you so much for enlightening us, giving us your time.
Pleasure.
In such a opaque space of real estate, murky, opaque space, right? You gave us a lot of clarity. Before parting off, I just want, last question to you would be, what would be one word of advice to property investors and home buyers from a legal standpoint?
See, there's no word of advice. I mean, my only thing is please consult experts before you take a call, whoever it is, especially lawyers, to double check the veracity of the title.
Right.
That is the most fundamental mistake which most investors and buyers make. We've had enough cases. Sir, we've been financing the builder for 30 years, he's never defaulted. But one default happens, your entire earnings goes for 6.
Stakes are so high, such a high ticket.
Because you start with
item.
5 lakhs, by the time you 20 years on that, that 5 lakhs turns to 10 crores. And that's one flick of button, money goes up. So double check everything, get your documentation in place before you, however trustworthy the
Seller
builder
may be, right.
or however friendly. Okay, just one last comment. People come to me, especially when they're doing investments into real estate or any kind of, सर इसको हम इतने साल से जानते हैं, में से क्या करेगा, पेपर आप क्यों कर रहे हैं? My only question to you is, सर कल अगर dispute में गया तब आप क्या करेंगे? That is why I would have the document in place today to preempt any dispute happening tomorrow. If you look at from that perspective, you realize why we lawyers keep harping about something. If you don't have the paperwork and goes to dispute tomorrow, what remedies do you have? That answers everything.
Absolutely. Thank you so much for your time.
Thank you, Mayank, for having me on. Pleasure having you.
And highly appreciate it.
Thank you.
Thank you.